And this afternoon, all the action is from the Supreme Court. The Attorney General, Godfrey Adeboadami, says nothing stops the Electoral Commission from declaring the Assin North parliamentary seat vacant. His comments comes in the wake of a Supreme Court ruling that restrains James Gyakye Quayson, the Member of Parliament, he used to be the Member of Parliament, from performing the parliamentary duties. Now, a Cape Coast High Court in July 2021 nullified the election of Mr. Quayson after it found that he owed allegiance to Canada at the time of filing his nomination forms to contest the polls. Michael Ankoma Nimfa, a resident of the constituency who filed this election petition in January 2022, initiated another action at the Supreme Court asking it to enforce this High Court judgment. The court today agreed with him on the matter. Court correspondent Joseph Akable has the rest of the story.
So Supreme Court judges Jones Doche, Mariam Owusu, Mensa Bonsu, Getri Tokonu, and Yoni Kulendi took the view that the MP should be restrained from performing parliamentary duties, while the other judges, Nene Amegacha and Agnes Doji, disagreed with that majority decision. The court said that the MP should no longer perform parliamentary duties or show up in Parliament or present himself as Member of Parliament for Assin North. The Attorney General believes this decision is in the right direction.
And I think that there ought to be even application of the law. There ought to be an equal application of the law. The same fate befell Adamu Dramani Sakande. He was not qualified at the time that nominations were opened, and we don't know what happened to him. He was subsequently declared ineligible, and for that matter, his seat was taken away. So there ought to be even application of the law. If it happened to Adamu Dramani Sakande of the MPP, yes, it also has to happen to a gentleman of the NDC who has also fallen foul of the same law. It means that as the High Court that had earlier on held, the seat for me, the people of Assin North will not be represented. And I think that we're enough for all these legal gymnastics that have been employed by the lawyers for Assin North. Perhaps the by-election should have been conducted long ago. And I, in my view, think that there should even nothing in the way of the Electoral Commission to declare the seat vacant. The High Court has ruled, given a judgment, determining the status of the gentleman as not qualified to have stood for election, and had actually cancelled the election conducted in the Assin North constituency. And the Court of Appeal subsequently struck out this appeal for non-compliance with the rules of the Court of Appeal. So there's no appeal pending. And I think the way is clear. But of course, the Supreme Court has ordered an expedited hearing and determination of this matter. Yes, I believe that the Supreme Court hearing definitely will also affirm all the principles of law that I have indicated had early on been established by the courts of Ghana.
A member of the NDC legal team, Baba Jamal, disagrees.
The Supreme Court has given its ruling, but we vehemently disagree with their position. I think that it is a sad day for all of us. That if what it means is that Assin North is also not going to have representation in Parliament for as long as this case lasts. That is a sad situation, because there are precedents in this country. We all remember the case in Ayawaso, West Wagon, where the lady was allowed to stay in Parliament.
Frank Davis, however, believes that the decision is a step in the right direction.
The right of representation is not a stricture by itself. The right of representation is steeped in law. You can't have an illegible person running around as a member of Parliament for a constituency when he is not. It obviously leads to a mutilation of the sovereign will of the people of Assin North. They are better off now without someone who is parading as a member of Parliament whilst he is not, whilst we await the decision of this court. The mere fact that they don't have to quote a member of Parliament at this time does not, in any event, strip them of what they are entitled to as citizens of this country. At any particular point in time, there will be a needed representation from the new Patriotic Party for the Assin North constituency.
This means that for now, the people of Assin North will be without a member of Parliament till the Supreme Court determines the substantive matter that has been filed. For joining us from the Supreme Court, my name is Joseph Akable.
Well, in fact, this is just the beginning of the case. Let's cross over now to the Assin North constituency itself in the central region for some reactions by constituents who are also learning of the Supreme Court's ruling. Correspondent Richard Kujonyako joins us on Zoom with more. Richard, I'm sure that you've been around town. What reactions are you getting on this latest ruling by the court?
Well, so the reactions are mixed, while others are saying that they are doing things deliberately to take their member of parliament from parliament. Others are also saying that, well, it serves him right, he should have done the right thing. So I moved to the constituency, spoke with market women, spoke with traders, spoke with the party people, the NDC, MPP. They all have different versions of their story. And so they are saying for the NDC in the constituency, they say that they should bring it on. If it is the by-election that they want, they will beat the MPP anytime that the by-election is declared. For the MPP, they feel that, well, they've been vindicated because the man did not use the right processes to get to parliament, and so they will do everything possible to unseat him once the by-election is declared in that particular constituency.
Jana mosquito ekano debia in the crisis here wo mbra ne yento abasisi na de ye wo hwe ba bia wo mo beda enti ye ya ready say ye twen omo ye nso omo da kumpoda ye ne wo mo beko sania wo mo call ye call 2020 election na wo mo gina bonten na wo mo etu mfuturo na wo mo twa adapa entoaba enti wo man kasa wo mo adwuma wo mo aye no wo krom hia no ana be kire wo say nkrofo nto abama wo mo bubu nkrofo store dan ama nipa fama ye de bade ewu no compensation up to date muntumi ye de bade ensi dan no enfema wo na mo sori a obi a wo aba obeboa no so a mo pese mo be man pa no obede obeboa minua o man be na yetimi your man be na yetimi CCI. People are taking this Ghana as their own bona fide property, especially our judicial service. Osha Shedia or mine since echo or mine or my fan say or bona fide property. Eti yabese yenu anuma mo ye NDC for mo ye NDC for papa ni who don't know. Sa nyama echo shunano say eba say ye kwakọ to ababema. Mo nyina mo support NDC because NDC na ama Assin North anom aye Assin North. Nana Akufo-Addo Nenkro.
Joko si na so amompe no. Ye de brekwase de sedare. Ha ye nya ye pedikrem. Ye mpu obia de se obi obebe bia no amwa ya. E bi se ye ntumi nkodi obi ati na de bia. Bleku ya ye dwadi ye di nyina aye basa. Ye hunu so nti. Joko si ono na baba bua ye Assin North hante. Ono an ye pelu okradue. Ye mpu obia wa ha. Ono an ye pe.
Emra na ye ka masem. Sabam no kase. So the court did ruling Nabano. We check Mami Kabi, the moon for swa, a minute, ye di whom and for swa. Until we are bano, maybe say at Papa. If you say, where he say, Ubiko Viana dear, no bitching who cadia. Yes, a Madame Juma. Says to be Mikuyo be board and Yachimia, will be one, and then the able to meet me. No, I cannot teach you, Nambrana Yajum. Into the court Nasi Bebre, we ain't to Quasam, and my who your tear was Unian Mimiano. Media the make person can say yeah sabasa if say amasa nki hu nyankopa no manya nti medina mas kasa fide kase so ma do bibia ase na maka say we aban koto ba beda ne mo ye first letter commission ode asamfo chef for baba aw ba kurum so am say kurum ayedin ntokwa bi anim if say yamra na ye de adwuma we ebi asipan so be kai abusa kandia esi wo ma breso Trina Manukoda Mumpo. And this way, no, and ya fee na emrano, because I lawyer for yan or motoha, a judge for yan or motoha, or mubia, a ba, mribia, a toya, a quay pinching and MPP the copy court, or Mukria, Netna, as someone so mubia, and the see answers uncle of Okria sooner, or motoha, or moving to emradie, a yamra, as I say, Yadia Juma, Croa, and as on Maya, emrenimuno, a chrono, a minor, and ya on my part. Enti de kopon ase se enei bibia akode din a ye san abeto abanfor mesre minuanom obia anka na komantu ne yem na ye nyina no enka mom na ye ne ye a oman no na edi ho mfaso na mentime ho ase makotwe sekan me kasa tie we ma ye se no emfa mfaso bia amra ye
na mom se yankopon ya adum na electoral commission esan de da foforo ba se yento aba ye nyina akoka bom ne yato na de obenwini no eno ase ye pempuntuo wa Assin North na ye de akoye.
And these are the reactions we're getting from the Assin North constituency. In fact, many of you may have challenges understanding what exactly these persons have been saying in the local dialect. Richard Kojo Nyako is still with us on Zoom. Richard, so break it down for us, the reactions we're getting and what simply the residents have been saying in the local dialect.
So we take the first two people, and they are saying that it is only Gyakye Quayson they know. The man came all the way from Canada to help them. If they look at their constituency, the previous MPs that came never helped them, but they have looked at the works of Mr. Gyakye Quayson in the constituency, and they feel that he's the right person to help the constituency, and so they don't know anybody apart from Gyakye Quayson. And so should the Electoral Commission declare that a seat is vacant and there is a by-election, they don't know anybody other than Gyakye Quayson, and so that is what they are saying. The other two are also using the law. They say that it is victory for the law and democracy because if someone steals something from the market and the person would be arrested and put before court, it's the same law that has been applied here. And so people should stop being emotional, right? Because it was used in the case of Adamu Dramani Sakandi, and so it is the same law that is enforced now. And so these are the reactions from the constituency. Right.
I'm grateful, and Richard will continue to keep an eye on the constituency and bring you minute by minute update on what's happening. In fact, we're still watching the story, but what exactly are the implications of this Supreme Court ruling, and particularly when we know that the minority in Parliament may lose one of their members, which will mean that there will be a tilt, obviously, in Parliament as we speak. No more a hang situation there right now. But there's one man whose judgment was also given recently that dwells on the issue of quorum and the numbers in the House. Justice Abdullah is a private legal practitioner. He's joining us live Zoom to take his thoughts on this matter and some other issues that are developing on this. Justice, thank you for making some time for us here on The Pulse. So first of all, your impression about the ruling that we're getting from the Supreme Court on this matter.
The difficulty with this ruling, I think this was expected naturally, considering the line of decisions that have greeted the election, in fact, the petition against the Assin North MP. The moment the High Court gave the decision it gave by throwing him out, I was hoping that they pursued vigorously the issue of the appeal, but unfortunately, it looks like they had to leave the appeal unprosecuted, which is why it got thrown out. Now, the moment your appeal gets thrown out, it literally makes the rest of their applications that are pending very light to sustain any further activity going forward. And so, particularly when the Supreme Court once again threw out the issue of the reference for determination as to whether, as to the meaning of and the intentment of the Constitution when it says that, when in dealing with the period of time that a person really loses his nationality or gains his nationality. Right. And for me, that the moment that was off, it for me appeared to be what has become known as the straw that broke the camel's back. Right,
but many experts say that this was predicted long time ago, and that what we need now may be a by-election. You agree with that?
A by-election will be very difficult, considering that the case has not it's not exhausted at this moment. For a by-election to be conducted, I think that would also bring in further serious litigations, because I am very sure that I think that there's still some processes pending before the Court of Appeal or the Supreme Court, and until those ones are exhausted, until there's a finality, it will be very difficult for the Electoral Commission to go ahead and declare this.
But I guess it's a matter of locals right now.
Communication.
Yeah.
Sorry.
I guess it's a matter of locals as we speak, because, and sorry for cutting through, we've had the Attorney General indicate that as of this moment, nothing bars the Electoral Commission from going ahead and declaring the seat vacant, and then we could have a by-election. Is it as simple as that?
I disagree, because the Electoral Commission would have to confer with Parliament to confirm whether or not that seat has been declared vacant. If those communications would have to be done before the Electoral Commission can make those pronouncements. The Electoral Commission does not work in a vacuum, and neither does it work with reports from media houses. It doesn't work that way. There have to be appropriate processes followed before the seat can be declared vacant. And I do not think that, as of this moment, I do not think that the Speaker would give that information for the Electoral Commission to declare the seat.
You're doubting...
There must be a formal communication.
Right, so what you're telling us is that you're doubting
there must be that formal communication, and right. The Speaker will not take that decision if there's even a single application that has the potential of holding the Assin seat intact for the NDC.
But in all honesty, the point is, how far could the NDC and by extension James Gyakye Quayson go? Particularly when we know this is the apex court we are talking about. Yes, indeed, the law does not bar them from varying from their initial rulings, but some would say that's unlikely given what we're seeing today.
Indeed, it's unlikely that the decisions will change. There is no turning back, for as far as I'm concerned. I think it's in his favor. It's very difficult, if not impossible, considering the trajectory of the case. But that is not to say that the NDC will be giving that easily. I do not think they will do that. And I remember hearing Baba Jamal making mention of the Judge Amon's case in 1996. That's Ayawaso West Walgon,
right,
where Judge Amon won the election. But the NDC candidate was given the right to be in Parliament. And they fought for her to stay on for the entire duration of the life of that Parliament. I think that was the fourth Parliament, or the third Parliament. They fought for him, for the lady to stay on throughout. Even though eventually Judge Amo was declared the winner of the election, he never had the opportunity to stay in Parliament, for even a day. And I think this is likely to be one of such cases that the two parties are likely to fight tooth and nail to ensure that even if the member of Parliament will come back to Parliament, even if, which is an unlikely situation, it will be such that it can only happen after the life of this Parliament. And so, guaranteed, we can take it for granted that NDC would remain, as far as this particular seat is concerned, 136. Going forward. But
I guess this is where the integrity, and this may be political, you feel free to comment on it. This is where the integrity of the Speaker will be tested, isn't it? Particularly when he stated on the floor of the House that exhaust all the legal means, now we have a ruling, and it's clear. All that's left is that the Speaker would have to declare the seats vacant. Are you expecting that from the Speaker?
I don't expect that from the Speaker, taking into consideration the three MPs that had been referred to the Privileges Committee. Those members of Parliament all belong to the MPP side. And it took well over 2 months before a reference was made. In fact, but for that reference made by the Speaker, no step was taken on this matter, which literally meant that those persons, considering on the face of the reference that was made by the Speaker, it's obvious that they've gone way beyond the 15-day rule, but they still remain in the books of Parliament as members of Parliament, which is something that is a bit very unusual. As far as the Constitution is concerned, that's clearly unusual, but that is what is presently facing us. And so, judging the Speaker from that stand, I am of the strongest opinion that he's likely not to take a decision on this one as well until the entire processes are exhausted.
And let's not forget as well that the principal legal advisor of government, and not just government, but also the state, is the Attorney General. If the Attorney General writes to the Electoral Commission, at least we know constitutionally no one can interfere with the activities of the Electoral Commission. But if the Attorney General gives the legal opinion that a by-election could be organized in the area, would you advise the Electoral Commission to go ahead and organize an election within the next few days?
First of all, such an advice could only go to the government and not to the Electoral Commission. The Electoral Commission doesn't take an advice directly from the Attorney General. unless the Electoral Commission itself make reference to the Attorney General for a legal opinion, in which case then they will be the Attorney General will be in the position to offer an opinion. Otherwise, it is likely not to happen that way. Second, even if the Attorney General makes such an advice to the Electoral Commission, what you are likely to face is that the EC will still have to go back to Parliament, find out and confirm whether indeed that seat has been declared vacant before they can take any further step. Until that communication also comes from the office of the Speaker, there will still be that hurdle that ought to be clear. And it will take more than a phone call or a communication between the AG and the Speaker's office for that to be resolved. I think it will take a lot.
Yeah, but I guess this is where the issue of separation of powers could also come through. Can the EC go ahead giving its constitutional powers without recourse to the Speaker of Parliament? And I guess that's where the big question is, knowing that the declaration by the Supreme Court today stands to be law.
Yeah, the declaration stands to be law, but the declaration of today only holds the member of Parliament at bay, not to step in Parliament. That can be enforced. That he will not be able to go there. Once this communication and once the judgment is communicated to the Speaker's office, that member of Parliament cannot step into the House of Parliament. That will be also contempt of the court, and Parliament could also hold in contempt of itself. And so, to that extent, as for going to Parliament, he cannot go there. But as to whether that is capable of depriving him of becoming a member of Parliament is a question that cannot be answered simply by this judgment.
Interesting. Very shortly, we'll be speaking to the counsel who argued the case out for James Gyakye Quayson. He'll be making some remarks on this matter shortly. But I also want to pick your thoughts on the general implications as well. There's also the issue about quorum in Parliament. Here's what we know, that at the time the controversial subject of the e-levy was being considered, there were divided opinions as to whether or not the quorum should have been 137 or 138. Given what we have now from the Supreme Court, will it go retrospect and will it take effect, given the fact that the quorum would now have to be 137 and not 138?
No, it remains that the quorum would be 138. And this is so because, first of all, this seat remains on a seat for the NDC, unless, of course, there is no pending application. Because remember, and I'm saying all these because it's a bit complicated, and you need to understand the nuances. First, even though the High Court has declared the seat vacant and literally dismissed the Member of Parliament, the Member of Parliament, as I understand, still has applications pending. The substantive appeal also, the substantive appeal was struck out and for want of prosecution. And I understand, if I stand corrected, I understand that they filed for relistement. If it is not accurate, then literally, if there's nothing pending, then that seat remains vacant. And in which case, now we have 274 members of Parliament. But the problem with this number is that it is still not half of members of Parliament, because the Constitution knows the members of Parliament, and the number is 275. So the absence or the presence of the additional member, whether his seat is declared vacant or otherwise, does not reduce the number of the numbers in Parliament. It only reduces the number of members of Parliament, but not the number of parliamentary seats that we have available. So until the seats are reduced, not the persons, until the seats are reduced, we still have 275 members of Parliament. And so we must still cross the 138 bridge in order to be able to form a quorum.
But if you listen to the Deputy Majority Leader, Apenyo Markin, he talks about the fact that at the time, for instance, the electronic transactions levy was being considered in Parliament, we didn't have a full complement of 275 MPs. You've heard that argument from him as well.
No, what you're not getting is that the law as of today is that our members of parliament is made of 275 members. If a member is removed, it does not change that. If a member is removed, it only means that that seat has to be refilled. And so if that seat is not filled, it does not reduce the number of parliamentarians. It only takes away that person from it. And so that person still has to be, so technically that seat is still available to be occupied. And so you still need to cross 127. So 127 still remains the number of members of parliament. And so notwithstanding the fact that 2, 3, 4, or even 10 people have been dismissed for some reasons, it doesn't reduce the number of our parliament to that less number. That is, let's say 265. It does not reduce it to 265. It still remains 275. So those seats would have to be filled. And so until that is done, you still at every point in time have to cross the constitutional threshold of having at least 138 numbers present in Parliament in order to be able to take a decision, in order for you to be able to take a decision going forward, in line with Justice Abdullahi and Attorney General.
So what's the way out for James Gyakye Quayson as we speak? What would be that perfect way out for him?
I believe that he has competent lawyers. He has to properly advise him. I may not have the entire facts and second opinion on the way forward for him. Right. However, I think I know for a fact, and from the conduct of the state, that they will be coming after him on the criminal charges, similar to what happened in Adamu Sakandi's case. Right. And so I would recommend strongly that he braces himself up for whatever will come forward from the state by way of criminal summons.
All right, then.
If it hasn't commenced already.
And I'm grateful that you've been able to spend some time with us. Justice Abdullahi, legal practitioner, also very famous for the recent quorum ruling by the Supreme Court. But there's one man who was at the center of this in court as well, who we just saw on our screens, Baba Jamal, one of the members of the National Democratic Congress, who has been advocating for the MP to hold himself out. He was in court today and joins us on the telephone lines now. Thank you so much, sir, for your time. So, is it over for your client?
Far from over. Very, very far from over. The Supreme Court's decision today is a sad day for our democracy. Sad day because I am surprised that the Supreme Court, knowing very well that there are substantive issues going on in the court, even in its own conclusion, it stated that the substantive case, which is about interpreting Article 94(2)(a), is before them. And also knowing that we have failed to relist the appeal processes at the appeals court, will go ahead and grant this injunction, denying the people of Assin the opportunity to be represented in Parliament. I find it very, very sad.
I mean, you are a lawyer, and you've seen many of such cases being dealt with in a like manner. And I'm sure most of your colleagues will also attest to the fact that when there's a judgment, that judgment ought to be enforced first. James Gyakye Quayson earlier last year was declared by a high court as someone who cannot hold himself out as member of parliament for the area.
No, listen.
Right.
Hello?
Yes, I'm with you, sir.
No, you see, listen, this is the most important thing. We need to understand the processes of our judicial system. The judicial system has indicated or given us the levels at which some particular cases end. When it comes to parliamentary challenge, it ends at the appeals court. As we talk now, the substantive appeal on the decision of the Cape Coast High Court has not been heard. And for that matter, nobody can claim that there is a conclusive position on the issue about the position of the Assin North.
But Jamal, what should be, and I'm taking you on this point, particularly because I know you're vexed with the matters and you very well understand what happens in the courts. What should be made of, for instance, the High Court ruling that was made in Cape Coast last year? What should be made of it, particularly when we know the appeal case has not been heard?
A judgment was made. Hello?
Yes, I'm with you.
A judgment was made, and the judgment has been appealed again.
That will not negate the ruling
now listen,
or the judgment of the court, you agree?
You can allow me to flow. You
yes,
understand
precisely.
where I'm coming from.
Yeah.
Because if the judgment has been given by the Cape Coast High Court, and it has been appealed, but there is, at the appeals court, there was an additional appeal position that was canvassed. That was canvassed even at the High Court, where we asked for a referral of Article 94(2)A to the Supreme Court for interpretation when it comes to the issue of allegiance and all those things. The Supreme Court, the High Court judge disagreed with us, and at that point, the lawyers for Mr. Nifa, Frank Davis, and his team, they opposed our decision to ask for a referral to the Supreme Court for interpretation. They opposed it. We went to the appeals court. They still opposed it. Now, then we go to the Supreme Court because the appeals court take a decision to strike out our case and for lack of compliance or whatever. So we filed a certiorari to strike out that case. Then they now turn around, go and file a writ for interpretation, something they have opposed at the High Court level, at the appeals court level. They go to the High Court to file a writ for interpretation on the same 294(2)A, and then file an injunction that the MP should be injuncted. What we are saying is that in Tetim and South, even though it's a High Court, when we filed for injunction against the MP for Tetim and South, the judge, the court was of the view, and I think that it was a far better position, was of the view that by injuncting that MP, you are denying the people of Tetim and South representation in Parliament. So it is better to keep the candidate there or the MP there until the final determination of the case. And this is in line with the decisions of the court, taking it from Teresa Tego's time since 1996 all the way down. So courts have been reluctant to injunct MPs when it comes to their representation in Parliament because the people's representation is very, very paramount. That's why we are surprised that the Supreme Court will go ahead and claim that there's a pending case before them and go ahead to injunct the MP. So it means that for now, what we need to understand is that the seat has not been declared vacant. No. The seat, the MP has just been injuncted. If you are injuncted, it does not mean that you have been what? You have been kicked out completely. It does not mean that way. What it means is that for now, you can't hold yourself up as an MP or you can attend on Parliament. But there are substantive cases that are before both the appeals court and the Supreme Court. But we thought that we were of the view that the Supreme Court would have been consistent with the various decisions of various high courts.
Right.
When they always make sure that they keep representation in Parliament for the people before, but not to injunct the people and deny.
But Baba Jamal, in all of this, right? In all of this, and some are being very blunt with you to tell you that without prejudice to the case that's before the court, that put your activities in order, try and campaign because a by-election is imminent. What do you say to such people who say, I mean, there's no chance of success for the NDC at this time?
Today's decision at the Supreme Court was 5-2. That alone tells you that there is some chance of success when we go ahead. Do you understand? It was not unanimous. It was 5-2. So it means that there is some, at least 2 out of the 7, might have agreed with us, because we have not seen the full judgment, might have agreed with us that our position is the right position. Do you understand?
Right.
So if everybody is talking about saying that we should just prepare for by-election, whatever it is, it is now has to go through the process of even going to Parliament, from Parliament to EC, before even whatever will happen to happen. But for now, we are going to take the necessary steps that we should take as lawyers. And of course, our lead team, Mr. Gyakye, has made it clear that he always wants to exhaust processes and ensure that the right things are done.
So tell us about the processes. Tell us about the processes. What's next? What's the NDC doing?
For now, the team is here to meet and to take those decisions. But what I'm saying is that we want to ensure it's not about going and maybe losing.
But you were in court today. So judging from what's transpired in court, are you likely to contest that decision again?
What I can tell you is that we don't agree with the decision. What I can tell you now is that we don't agree with the decision. And what I also tell you is that we think that it is a sad day for democracy. It is not the best for our democracy. It now follows that a lot of high courts now taking clue from the Supreme Court can go ahead and even injunct people before they enter Parliament.
Right.
You see, and that is not good for our democracy.
Okay.
As we talk now,
some are saying, and because we don't have all of the time, let's try and touch on all of the matters. For instance, the argument is that you have an opportunity to tackle or to correct the wrong in Parliament, what you deem as wrong in Parliament. The question about the Speaker not declaring the seats vacant. What would you suggest in this case? Because the Speaker himself has given an assurance that, well, I'll go ahead and declare the seats vacant if we have a ruling from the Supreme Court, for instance.
That would be for the Speaker to satisfy himself that there is no any case pending against the MP. That is for the Speaker to.
But what would you advise the Speaker?
As it stands now, I know that there are 2 substantive matters one before the Supreme Court and one before the High Court, and for that matter, it is not conclusive for anybody to act and say that seat should be vacant.
So because you are invariably, and I'm sorry for cutting through.
Which you can declare the seat vacant has been appealed against, and it has been relisted at the appeals court.
Invariably, you're asking the Speaker not to declare the seat vacant.
It's not that I'm asking the Speaker. I'm saying that it is for the Speaker to satisfy himself that there are no issues about or pending matters in respect of the Assin North. If he satisfies himself and he thinks that it is the right thing to do, it is his decision to take. But in our opinion, it will be taking a hasty decision by declaring that seat vacant when the order or the judgment from the Cape Coast Court has been appealed against and relisted at the appeals court, and there's also the matter of interpretation of Article 94(2)(a), on which some of the part of the judgment the court based its decision on.
Baba Jamal, you are a known member of Parliament. I mean, a known member of the National Democratic Congress. There's no need to be pretending about this. You know the Speaker too well. The party rank and file would obviously be expecting something from the Speaker, someone who belongs to your party as well. Do you feel that
he belongs to our party? He belongs to our party, but he presided to pass the.
Let's not take the politics away from this.
No, it tells you that he's impartial because he is a member of our party.
Precisely. I'm not saying you should tie the hands of the Speaker. I'm just asking, for instance, what you would advise that the NDC do about this? Would you consider talking to the Speaker about this?
I've already told you my position that it is for the Speaker to satisfy himself. But in our opinion, it is clear that it will be a hasty decision to go ahead and declare the seat vacant when you are aware, when it is obvious, when it is clear, and even the Supreme Court decision itself has confirmed that there is a substantive case of interpretation before it. And also, there is an appeal against the decision of which. Now, which decision are we talking about? The decision I'm talking about is a decision from Cape Coast High Court. Is that not it? If it is a decision from Cape Coast High Court, that decision, there is a listment of that appeal, and we are yet to move that motion. So there is some form of appeal against that. Now, that decision also quoted part of Article 94(2)(a), and that is what is now before the Supreme Court. So every reasonable person you should expect, that will satisfy himself that all these cases have been dealt with before you take any step to declare the seat vacant. So not to say I'm advising the Speaker or telling him what to do. In our opinion, there are still cases to be dealt with, and they should not, and therefore that should stop them from declaring the seat vacant.
But Baba Jamal, we need to go in all of this in just a minute. We know that the person at the center of this case is James Gyakye Quayson himself. In fact, he's your client, and obviously you would be engaging him on the way forward. Have you spoken to him after court today? And what sense are you getting from him? Is he opting for...
He was not in court today, and I have not had the opportunity since I left court to meet with him. But as usual, and as I know him, he's a strong person, a fine gentleman who is taking everything in his stride. He knows he has not done anything wrong. He knows he genuinely renounced his Canadian citizenship. So he knows he has a clean hand. And he still believes in the people of Assin North, that they genuinely voted for him. He is the right person to represent them in Parliament. So I can assure you that he is in high spirit, and together with him, we'll fight this thing to its logical conclusion.
Okay, then. We'll see about that. Baba Jamal, thank you for your time. He's a member of the NDC legal team. This morning, politics.